Welcome to Lawyer versus Lawyer. This is Gary Berger. Welcome, Stephen.
Hey, Gary. Good to be back.
We are here with Stephen Gerring of the Gerring Law firm and talking about, we just did an episode on how to maximize your case value in the claim stage. Now what I would like to talk about, and is actually, well, Steve, what do you want to talk about? Because this was your idea, totally your idea. I don't want to take credit for it.
All right, well, let's talk about how the adjusters can sometimes trick you and try to sell you that your case is worth less than you think it is.
All right, can I start? Or no, you start. You're my guest. You start. Give me one. Give me your top one, or one of them.
I'll give you one of them. I don't know if it's a top one necessarily, but how about the adjuster claims that too much time has lapsed between the accident and your client's first treatment.
All right, that's true. So they go in and they say, hey, you didn't go to the doctor for 3 weeks or 30 days. So how do you? And so therefore, your client wasn't injured, and we're not going to pay for any of the medical. How do you fight that?
There are a lot of different ways to fight it, but one of them is make sure that when you sign up a case, you have already screened for this in your initial intake. But something else that you can do is you can send them proof that your client did treat somewhere or thought about it. I'll share you a story that I just had on a case I just settled. My client from Great Britain, and she's not very familiar with how the medical system works here, and she was in an accident, did not know where to get treatment, and she had this log of emails that she provided me between her and her insurance company asking where she could go to get medical treatment. And she did it because she knew she had medical payments coverage, and they had said they would pay for the treatment that she would get, but she didn't know where to go. So I was able to use that when it came time to make the demand to the third-party adjuster to show them, hey, look, here's how my client was actually injured, and here's why she didn't treat, in the initial 30 days after the accident.
Right. Good. That's what I was going to say. I always, great to screen them. And then, whenever you get that call in, that's why the other reason why you recommend go to an urgent care, go get treatment right away to a client. It's not that you're trying to steer medical. This adjuster later on is going to be a jerk about whether or not your client went to get treatment right away, even if it wouldn't have mattered. And then that's what I do too. I have a good reason why. I say, listen, they didn't go for 3 weeks or blah, 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 blah. And I've taken cases before that other clients have rejected, and I filed suit and fought for clients because they had a good story. They said, listen, I was working, I was out of town, or my wife had a baby, or this is the other one I get. I have a number of cases, I've had this for years, but a number of cases with pregnant women who say, yeah, I got in a wreck, I went to the urgent care, and then I was in Cairo. I'm not going to have anybody pressing on my baby. So I waited for 4 months, and then I had the baby, and then I went to treatment. I had the same damn back pain, and that's a good story. I will stand in front of a jury any day and tell that story. So what it ends up being is what is going to hold water with the jury.
Right.
Can I give you one now too?
Sure.
Can I take a turn?
Yeah.
It's similar to yours, but it's like I looked at the pictures. It's a low impact collision. The medicine, you should only have 6 weeks of treatment no matter what, and then you're better. So we're only going to pay for 6 weeks of treatment.
Yeah, that's a very frustrating one.
That is. Is that on your list?
That is on my list, yes. Or the first thing you said, the low property damage one, is a very, very common one.
Yep, you have this on yours.
It's as if though no one has ever been injured in a low-speed crash before, and you're the first one to ever make that.
No one can go to a chiropractor for more than 2 months. There are 6 weeks and there's different doctors who they'll hire Bernard Randolph, and he says that all the time. I took his deposition 2 months ago. I'm like, dude, and Frank Petrovich. Neither of them will treat your client. They'll see your client, and they'll write the same report that you should have treated. Yes, you were injured. Yes, you should have treated for 6 weeks, everything after that. I'm like, well, what about someone who herniates a disc and needs that? Or what about someone who, there's a lot of injuries that last longer than 6 weeks. I mean, so the way that I combat that, and then I'll turn it over to you, is I say, well, I mean, not everybody's average. I mean, yes, on average, people may work for 6 weeks, but that means some people treat for 2 weeks and some people treat for 2 months, and then there's an average of 6 weeks. So an average means that, and if you look at the treatment in the records, the person still had pain and symptoms, or they're trying to go back to work. I mean, you have a duty to mitigate your damages and go back to work and work. Well, they're going to the chiropractor so that they can work, and they got a heavy labor job, or there's a variety of reasons, many reasons why people treat for a long time. And if you've ever been injured and you pick juries in this, you talk to these people, they still, you still remember that car wreck or that knee injury you had in high school or this or that, because it still gives you problems later in life. And so it's just, they can say that, but it doesn't fly with me.
Yeah, and everyone's different. I will say, you have to understand your client's story. So I think all of this comes down to the best tip, which I think is to do your homework, to understand your client's story. And you'll be able to figure out, well, hey, are they not someone that likes to go get medical treatment? I said in the other episode we did, I'm not really someone that likes to go to the doctor a lot myself. And I can see that in certain clients of mine where, other clients you have may go to the doctor, 35 times over an issue. You may have another one that goes once or twice.
Right.
And that's the way that people are. You can't change it, but what you can do is you can let the adjuster know that and do the homework to understand that.
And the adjuster can say that, but I don't, I think even like I have clients, they'll treat for a while, we'll do it, we'll file suit, and then it'll be like 6 months later and they say, Leon, I'm still having this, and this problem. I say, go back and get another round of PT and another injection. And they go do it and they're fine. And then some people need that maintenance to keep them, doing the stuff they like. Sometimes you need that from a car wreck. So
combating the low speed impact issue, I've had some success with explaining that it's not necessarily the speed the accident was in, it's the relative weight of the two vehicles that were in the accident.
So that's so let's distinguish it. This is a third argument that regardless of the duration of treatment or whether you got treatment, the adjuster says it was a low speed impact. It couldn't have hurt your client, right?
Right.
So how do you combat that with the adjuster? What do you tell them?
If the facts of your case support it, you point out the weight differential between the vehicles, because the studies show that if a heavier vehicle hits a much lighter vehicle, that the effects from whiplash can be severe or just as severe as if the two vehicles that were the same weight had hit each other. And I don't have all of these stats off the top of my head to back this up.
Force equals mass times acceleration. I use this all the time.
Yeah.
And I do this in trial, and we talk about it. Is that so? That's what so what is the force on the vehicle that was rear-ended? Force equals mass times acceleration. Mm-hmm. So you can have a 60,000 pound or 80,000 pound tractor trailer going 5 miles an hour and rear-end your client, or you can have a 5,000 pound car rear-end your client. Force equals mass times acceleration. And if it's exactly what you're saying, if you're a big SUV or a tractor trailer and you hit somebody, you have more force because you have more mass, even if the speed is the same. The other thing is that it depends on the kind of car. Sometimes car bumpers and stuff are made to bounce back and do something, but I have people where they're hit on a trailer hitch, or you hit the frame of the car, it bends their whole car and does all this stuff. So I had a case we just settled, we filed suit and litigated it where, actually this one we're still in. I've had this where they said, oh look, there's not a lot of property damage, but then I showed them all the pictures and how it broke the seat. And the person's seat is back and all the airbags are gone. And I can say, you can say that because you want to look at this picture, but look at all the other shit that happened in this. This is not a low-speed accident. You're crazy.
Yeah.
I've had guys with hitches on cars because they weld that hitch onto the frame. And it said, it hit my hitch. It punched a hole in the guy that rear-ended me. I don't have a lot of damage to the stuff, but let me tell you, look inside my car. So take pictures at the scene. But there's other ways to do it. You can talk about I mean, all that force gets translated, and it really jogs people. And so,
And when I said I didn't have the stats, what I meant is I don't have it memorized. There are meta studies that have been done that show specifically your likelihood of injury from different forces at low speed impact. And I think there was a study, really comprehensive study done in Canada on this issue. I can maybe send for the show notes.
There's some literature out there, and you don't want to have to hire an expert to do it. Do you send that literature to the adjuster?
I have not yet. Usually I just point out the simple physics argument, as you very eloquently just explained. And that often, if it is the case in your client's case, or that those are the facts, then you'll have success with that argument.
Yeah. So here's one. Did you go last, or is it my turn or your turn?
I think it's my turn.
All right, you go.
All right. The adjuster will evaluate the case based on the amount of the outstanding medical bills only,
Instead of
your client's injuries.
yes.
And I bring this up because I have had some cases with very small amount of medical bills result in high settlements. And the reason that they have done that is because your client maybe didn't treat a lot, or because it's a type of injury that doesn't require a lot of treatment. For example, if you break your ribs, you're not going to go to the doctor a lot, you're not going to have a lot of follow-up care, but it's a very painful process. You're going to be off your feet for a period of time, 4 to 6 weeks. You're going to have some significant problems with activities of daily living. And sometimes, actually most of the time, you'll see an adjuster say, well, there's only this amount owed, so I'm not going to pay you the full limits here because of that. And I struggled with this as an early lawyer because there's some wisdom out there in the ether, and I don't honestly know anyone who specifically subscribes to this, but I'm sure you've encountered it before, where cases are worth 2.5 times the outstanding medical bills. Have you heard that before?
I say 3 times.
But you know what I'm talking about. There's that general thing out there that says that. And I think that insurance companies sometimes will play off that.
Absolutely, they do that.
When you are negotiating a case with them, especially a case like the one I'm referring to, where they might even give you 3 times specials immediately on a case where it's going to be worth more than that in the long run. And they do it because there are a lot of lawyers, I think, who don't necessarily practice personal injury law that know that formula and may be inclined to take that settlement because they've heard that is fair.
That's right.
Do you think that's true?
I think that can happen a lot. I think that that there can be this formula, and it is an issue. It is an issue. And so the question is, how do you deal with the adjuster? And I think what I do, and I think just to repeat, I just tell the adjuster, I say, listen, you're not going to have big medical bills for fractured ribs or broken sternum or fractured pelvis. They just lay you in bed and you got to heal. There's no surgeries. There's not, and that's it. Or the other thing too that I get a lot is I get a bulging or a herniated disc that's non-operable, but the person, that's going to be with them for the rest of their life, and it's really painful, and it's really a Hobson's choice when let's say you're 25 and you have a herniated disc in your neck. Are you going to get a surgery and get metal in your neck and you're going to go back to work in a heavy labor job? Or are you going to see if maybe that goes away? That's a hard decision at a young age. And so my view is those cases. So one of the things you do is you get the diagnostic tests and the medical opinions to back up the fact that there is this significant injury. You need to get that. So you need to get a weighted MRI or get an MRI or do a repeat MRI or figure out why your client is still severely symptomatic even though there's been a little bit of treatment. A lot of times in these broken bones, there's not a lot of treatment, and then they heal, but you know what? They have permanent numbness, or they don't have the same range of motion, or they don't have the strength. And I see you're nodding while we're talking. There's a whole host of things, and that's all. And you say this well, is you got to know your client, and you do. You got to have a real relationship with your client to be able to give a voice for that. And then you just tell the adjuster that and say, listen, you may be able to settle that with some other lawyers, like the ones you're talking about, but that ain't going to fly with me and my firm, and I'm sorry, but I got to stand up for this client, and that's just what we're going to do.
Yeah.
Until I'm going to keep going until I persuade you of the wisdom of my position.
And it comes down to doing the homework on your client's situation, knowing what they're physically not able to do anymore after the injury, I think is an important part of persuading the adjuster to offer you more.
Here's the problem, though, is there are some people that go to trial and try these cases, and the jury doesn't give them money for that herniated disc.
Mm-hmm.
Or they don't give them a high return. There are people that try cases and have this, that, or the other thing, and maybe don't try them well. I don't know. I'm not going to. Juries are pretty smart. I think they figure this stuff out pretty accurately, but I don't know why. So the problem is, in a way, too, is the adjuster has people telling them, doesn't matter, the jury's not going to give them that, because ultimately the value of this case is informed by what juries do to award people damages. And so that's right. So
on this point too, I think
yep.
an insurance company's evaluation of cases can go both ways. Sometimes you have a client that went to a medical provider that maybe charges a lot more than they should.
Yeah.
Have you ever encountered this before?
Yeah.
I had a case with a chiropractor here in town. I've only had one case with them. My client decided to go there on their own. I got the bill, and they were charging $500 per visit.
And do you think they would have? Do you think anybody pays that in really, or only if you have an auto accident case and the chiro's trying to be greedy?
That's the only way that they're ever getting $500 per visit.
Ever.
So I don't know if you can necessarily define what's the reasonable amount of.
I can.
In this area, is it just
I have a
1.5 times Medicare rate?
Now I'm old.
Okay.
So sometimes my value of money is old.
Okay.
But I have this. I've had this for a long time. I think at the end of the day, if the chiro makes $100 a visit, that's pretty fair.
Okay.
Maybe it's a little bit. If there's X-rays and stuff, I think that's a little bit more. But if they go see a chiropractor 15 times, I kind of think $1,500 is okay. If it's $2,000, I'm not going to complain that much. But if it's $5,000 for 15 visits, I know there's games being played. But then you got to look at the bill. Is there an MRI there? Is there an injection there? If there is, then that should be charged a lot more too. So there are good chiros whose bills get bigger because they are also coordinating diagnostic tests, and that's fine with me.
Does MRIs?
I do.
Oh,
I do. I will not order, but they will say, "Look."
I mean, in office, like in part of the
no,
bill.
not in office. They'll
happens.
send them out to someone else.
Yeah.
So they'll say, "Hey, I've treated you for 6 weeks or 8 weeks or 3 months. You're not better. You're still having referred pain in your arm or in your leg and stuff. Let's get you out for an MRI because there's something else going on here." And then, or they will, chiros will have a partnership with an MD that can order it, or there's various ways.
Well, I think the $100 a visit you're referring to is somewhat, has to do with the Medicare rates. I think a lot of medical bills are based on what Medicare pays for services, and I think that it's either 2.5 times Medicare is generally defined as reasonable. But the point is, sometimes you'll have medical providers that way overcharge. And I've heard other lawyers say, well, I think my case is not going great because they're not even offering the medical. And then you hear maybe what the medical is, and you see, well, that's
it can hamstring
way out of whack.
It can hamstring it. And yeah, it's hard. And that's hard to deal with because, I have this in another case right now, where the client went to someone else, you didn't know who they were, they're treating, you think everything is good, you get the bill, and you're like, this is going to be a real problem. So what you want to make sure you do is you communicate directly with the client, let them know the tension in that issue, blah, 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 and you try to resolve it as well as you can. Sometimes you use the lien reduction statute. Sometimes the adjuster's right. Right. And then sometimes I say, put this into me in writing, and the adjuster says this claim's bullshit, and then you send that to the chiropractor and you say, listen, here's the deal, and there's a variety of ways to deal with it. And
where it gets difficult are the costs for medical procedures from hospitals, because you have no choice as a consumer on that. Those costs are not known to you, especially if you are forced to go to get treatment after an accident. You are not selecting the hospital you go to often, and you all of a sudden are left with an insurance company saying, well, that CT scan is not what is typical in your area. And I'll share a short story I had fairly recently on a case where I had a client that went to probably the second biggest medical provider, second biggest hospital system in St. Louis, and we submitted the bills. It was like $1,500 for a CT scan, and the adjuster said, no, that's not reasonable customary in the area. Usually what we accept is $500 for a CT scan. And I didn't think that was necessarily right, but all right, fine. Well, later the day, I talked to, and just happened to talk to, someone that was responsible for the billing of the biggest hospital in the St. Louis area, who is an expert at medical bills and knowing how much the hospitals charge specifically in this region. And they say that they charged $200 more than the other hospital, who the adjuster said was overcharging. Medical bills are very difficult to understand upfront by your client.
There's a lot. We could do a podcast. So St. Anthony's in South St. Louis used to have a practice they would get a client in, a patient in, they charge them in the ER and charge them, and they charge their health insurance, and as soon as they found out there was a car accident case, they'd pay the health insurance back and then bill and assert a lien for the entire amount of treatment. They'd change it. And then there was some class action cases. That practice is also being done in Kansas City, and there were some class action cases that did that. I always thought that was unethical and a breach of contract, because the providers have contracts with the insurance companies to honor that, and they get paid from the insurance company. And so there's a lot of people that bill great and fair. There's also people that take advantage of this system. It's part of the lawyer's duty to be vigilant about that, because that claims adjuster, these insurance companies are smart, they're savvy, they're professionals at this, just like you and I are. They know if that bill is exaggerated, and I use that against the lien holders later. Keep your clients away from people who charge like that, because it's only going to be a big problem down the road, and you're going to get in a fight about it. And in Missouri,
you can't.
The other time, sorry.
Sometimes you can if it's a hospital.
You can do a motion to adjudicate the lien in the settlement,
true.
in the lawsuit. So sometimes I have had cases where I have to file a lawsuit just to adjudicate the lien. Or if I'm in suit and I'm having disputes, I don't dismiss the case because I need to do a motion to adjudicate lien. And I think over the years, I've only argued one. I file them sometimes, and then they cave the day before the hearing. We don't want to send a lawyer there, blah, blah, blah. Yeah. But you go and you're just frank with the court. You say, hey, here's the bill. Here's what I offered them. This is why it's unfair. We want you to adjudicate this lien down, because I have cases on this. Courts have inherent power to adjudicate the liens in a case. And so that's your ultimate, it's kind of the atom bomb. You can try to negotiate, you can do this, but ultimately I had to file a motion to adjudicate lien. And then they always call you the day before. And then they cave.
They're willing
or
to
you keep it in your trust account and you do it. Now let me also tell you, one other thing I was thinking of while we were talking is, remember to use the, when you're talking about these bills and stuff with the adjuster, remember to use the policy limits as a threat of bad faith. So, so jumping back to the point before, like let's say you have a herniated disc, or you have a broken bone, or you have a fractured rib or sternum, something where the injury is more than the medical bills would suggest. Then you need to start talking about limits and making a bad faith demand. And so, let's say there's $25,000 or $50,000 limits. You get the limits, you make that demand, you give them a bunch of chances to settle it, and then you withdraw that and you go file suit, and you can go to trial and tell the jury this poor 25-year-old kid's gonna have a herniated disc for the rest of his life, and he's gonna need a surgery. It's not gonna be today or tomorrow because this kid's tough, but and the kid weight lifts, and the kid's compensating by doing all this. I have family members that we all have. I don't want to make it personal. We all have conditions and stuff, the kind of stuff you have to maintain, like exercising and yoga and different stuff you do to be able to do your activities of daily living. Some people have to do a lot just to do normal shit in life, and that's anyway. So remember you think about those policy limits, make that policy limit demand. Let me bring up.
Oh, can
Yep,
I ask
no,
you
go
one
ahead.
thing
Yep.
About policy limits, how often do you get the policy limits on cases?
A lot.
I do too, but not all the time.
No, because
Maybe.
sometimes it's not worth it. Sometimes you got a $20,000 case and there's a $100,000.
I meant how often do the insurance companies disclose that to you?
A lot of times they don't.
So,
And
was it
so
like 75%
they're
of the time
required
they
to
do?
in Illinois. They're not required to in Missouri.
Mhm.
I do it. I will file suit just to get policy limits sometimes.
Okay.
If my client is hurt and has a herniated disc and they won't tell me, I'll file suit just to get a policy limit, because I know if that adjuster won't tell me the policy limits, then that adjuster's not going to fairly settle that case. That's my conclusion. Now, I could be wrong. There are also times when the policy limits are so high, then you say, well, are you not telling me because there's like $1 million here? And they say, yeah, it's really high. Don't worry, you're not going to need to worry about it in this case. And I go, okay, are you going to treat me fairly in resolving it? Yes, I will, but I can't disclose it out. Okay. Or you can, I say, ask your insured if you can disclose it. And I also tell them that if it's a big case, it depends on the facts of the case.
Okay.
So the also thing you can do is you can say, well, listen, I'm not settling this case until I get an affidavit there's no other insurance and I've hit the maximum if my injuries are warranted. So it really depends is how bad are your injuries? Is this a $100,000 or $200,000 case? Well, then you need to know. The other reason you need to know is if you make a demand, then you can, the other way to do it is, I'm sorry, I'm rambling, but then you can make $1 million demand and then let them respond.
Is there any truth, and I heard this
But there's
recently,
no regulation that requires it in Missouri.
I want to ask you this, I'm going to put you on the spot. I heard at a plaintiff's lawyer's event recently that you can find out policy limits by asking an insurance agent friend to look it up for you.
Oh, you might be able to do that.
Is that true?
Maybe.
I've
But I
never
don't
tried
thi-
it before, but I don't know if I'd be comfortable with doing it.
Yeah, I don't know. I mean, I have a couple friends who do that. I don't know. Honestly,
Because it would save
how
you
is
the
that
headache.
gonna? If I have an adjuster who's refusing to say that, and to me, that's not negotiating in good faith.
They don't have to tell you the policy limits if their insured doesn't give them permission to, correct?
They have to. Policy limits are a federal rule initial disclosure. It's the first interrogatory. It's something they have to tell you. The reason why the federal laws and the Missouri laws say you have to do it in litigation, not in a claim stage, is that's fair. It's the only way to negotiate in good faith.
I'm talking about in the claim stage.
I know.
Which is important for what we're talking about here, where adjusters
Well, then I make my
Tricky.
demand.
Okay.
And I just sometimes I do two things. Sometimes I try to persuade them. I try to get them to ask the client, say they ain't going to settle without it. I say, do you tell your insured that they're going to get sued and served? And then either I go two directions. One is if it's a lower level case, I say, you know what? Let's just try to negotiate and see if I can settle this case so I don't delay stuff for my client. And I go that way. But if it's a big case with big injuries, I file suit and serve them one interrogatory, the insurance interrogatory, and then I do my second set of interrogatories for the rest. And I find out the insurance limits. A lot of, sometimes you don't need to fight that battle.
Okay.
Sometimes you don't need, because why does it, if it's a trucking company with $1 million policy and you have a $20,000 case, why do you care?
Sometimes you have a case where the policy limits is going to instruct the rest of what you do on the case.
Right. And then you file suit.
When you're trying to set up a bad faith.
Then you file suit.
So how can you set up a bad faith case if you file suit immediately?
You can file suit and then set up bad faith. Bad faith is independent of filing suit.
Okay.
It really is. So you can have a suit. You can also have a case that changes. You can have a case. You can file suit in a case, and your client treat, and then 4 months, 5 months into it, they can get a MRI and they need a surgery, and then your case went from a $50,000 case to a $250,000 case because they got a neck surgery. So the damages in your case can change you can have there's a lot of ways that can change. So you do not need to just do bad faith pre-suit.
Okay. I guess I haven't done many bad faith cases, so I'm not as aware.
We have
of
a
that.
protocol in our office about bad faith. We do the bad faith Missouri 90-day letter. We have a different procedure in Illinois. We target cases that have high damages.
Okay.
You're not saying it's going to be bad faith. We're giving them an opportunity to settle. But if we give them that opportunity and they don't, and they put their insured at risk, then that's bad faith.
This may be veering off topic a little bit, but
because I want to ask you about what do you do about the other thing is when they talk about something I encounter a lot, not a lot, but if their claims the injuries were pre-existing. But go ahead.
Oh, I was gonna. Could I further that last point for a second?
Yeah.
About bad faith.
Yeah.
Do you intend on using your time-limited letter under the new law as evidence in your bad faith case?
Yes, if I send the letter. If I don't care, then I don't send the letter. You don't have to do the Missouri 90-day letter to win a bad faith case. It's one piece of evidence.
So how else do you prove it without the...
You depose the adjuster and say, were you asked did you have 17 opportunities to settle this case? Did you settle the case the week before trial? Did you ever pay this? What's the most you paid to offer to settle this case?
It seems like the most clear way to show bad faith, though, would be by showing that letter.
In Missouri, not in Illinois.
Not in Illinois.
Yeah. That letter is to constrain and hurt that law in Missouri is to hurt bad faith cases, not to help them. Mm-hmm. But we do the letter, and then it's good evidence, but we do the letter, but then I also want to give them opportunities. I want to say, so like the perfect bad faith case is to have someone on the stand and saying, we asked them 42 times to settle this case. While the jury is out, we asked them to pay it. Then the jury came back and there was only $100,000 in limits, but the jury awarded $550,000 in damages. This is a bad faith case. So I don't think just the one and done 90-day letter is good enough. I think you want to have a better record, really showing that they're acting. You need to say you're acting in bad faith.
That's what I try to paper the file, as they say.
Exactly.
By sending documentation early and often to help your record later.
Right.
But I asked as a bad faith novice about that.
Well, you imagine putting the claims adjuster who made the decision on the stand at trial in a bad faith trial after the first trial that established damages. I mean, did we ask you to settle this case? Yeah. How many times? Mr. Gerring sent me 17 letters. That's really good evidence.
Yeah.
Now, can you get the letters into evidence? No, but the fact about whether he settled it and whether he was on notice and whether he did it still all comes in. That's not an evidentiary restriction on that, but it is an evidence. It just said the statute says to get a letter in demanding settlement on which you're going to premise a bad faith case, you have to comply with this.
And all the okay.
Let's move on to one topic before we're done. We've been going for about a half hour here. So, what if the adjuster says your claim? I think have we gotten all your? The only one I see we didn't get to. Well, they can try to use your client's medical records against you. You can. You got to look at the records and do it. But what do you do if you have a client who has a pre-existing medical condition?
You try to know that at intake, and I think it's very important if you're doing a personal injury firm that your intake shows that on there. And my intake is very small compared to I think a lot of people, but it's very effective because I have that listed on there where I can easily notate, what happened to someone before that may impact this current case. I think that if you overlook it at the intake phase, then it could really cost you later on down the line. Because when the adjuster tells you, those injuries are pre-existing, you should be able to combat them with why this is different now. And I think a big way to combat that is to have a good knowledge of your client's medical history.
Yeah, absolutely. And then, so you want to have the good knowledge, you want to have an explanation for it, and then, but then also, where the rubber meets the road is, what is that pre-existing condition? Did your client get I settled a case where my client got an injection 2 weeks before the car crash because he had ongoing permanent back problems. You got to deal with that.
Yeah.
That is significantly affects. And you need to talk about your client in the front end, say that's going to hurt you, and you need to be clear about that, and you need to be clear about distinguishing that. The other thing, though, is what if you have a client with pre-existing and then they were asymptomatic and stopped treating for 5 years and then get in and out of rec? You need to know that so you can tell the adjuster exactly what you're saying. My client did have a prior car wreck, did have this, that, or the other thing, but they were asymptomatic, blah, 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 and then they didn't treat for 5 years, and then they got in this wreck and then they treated a bunch. And it's really, what is the jury going to think? People get in multiple car wrecks. I mean, and in fact, as a sideline, I also have people who have one wreck, get treatment, and have another wreck. I have a bunch of these cases. And in those cases, almost always, I file one lawsuit with both accidents and let the defendants blame each other. I don't know what the answer is. I've done this many, many times.
I think cases where the adjuster says pre-existing injury and there's some documentation of it, they're aware of that other treatment, is usually a case where you're probably going to have to file a lawsuit on eventually anyway, because they're going to want to go through the discovery process of ordering, they're going to have their insurance company, their defense law firm order all your clients' records and know for certain, rather than relying on your clients' records that you provide to them. That seems to frequently happen to me.
The other thing, though, is you can't. I have that happen too. I give the claims adjusters pre-litigation a authorization, and I let them go to the primary care doctor and get 5 years of records, or go to the orthopod, or go to this. I tell them who the providers are, go get them, and they can go get them, and they see what it is. And I want to know that too. Look, you kind of want to know that before you file suit, because you got to, because it may be true that they have a point that the pre-existing condition is being the thing that causes it. However, I will also, sorry, go ahead.
There's also the human element that you have to take into account. No matter how well you know a client, they may have forgotten something that's pretty important.
All the time.
Yeah, very common.
All the time. It's my joke. I say, in a client interview, do you ever have a car wreck? No. Were you ever treated for neck injuries? No. Did you ever have any treatment your whole life for your neck? No. I have a record here that you saw a chiropractor 3 years ago. Oh yeah, that's because of my neck injury and my car wreck. And I'm like, oh my God. But that's okay. It's normal. It's right. Normal. It's not because people are hiding the ball. But in pre-existing injuries, you need to figure out what it is. The defense adjuster is going to maximize it. Your job is to call it like it is, not even minimize it, because honestly, you have to talk to your client realistically and say, listen, I'm sorry, but juries, don't blame it on yourself. You and the juries are just not going to think this is all related, because you had this other car wreck, the prior one, you had all this property damage and you treated forever, and now this car wreck, there's nothing. How are you injured? But you have to
differentiate.
And you need to make sure the medical people are going to support you. You don't want to go running with a case because you think something, and then you go call the doctor up 2 years later and they say, I think this is all from the prior one. But most doctors will know. Here's another little thing you can do that I think this is why you're waiting to listen to this whole podcast.
All right.
Is judo it. Use that to your advantage. So your client 5 years ago had an MRI and treatment. Go have them get a new MRI in this case. Compare the two MRIs. I've done this before, where the doctor says, yeah, they had a prior thing. Look at this MRI. This disc was not herniated. And then you go this MRI and you say, look, this disc is herniated. It's through the thecal sac and it's impinging on the spinal cord, and that's why this patient has different. This is different, and it's a new herniation. Then you embrace the prior treatment. You put that on in your case, and it show the jury why this is totally new, and you use the prior medical to prove it. The other thing is adjusters are going to want to conflate prior problems. The prior problem may have been low back, and the problem here is a neck because of the mechanism. So look at the parts of the body too. Make sure it's the right side of the body. Make sure it's the same side of the spine. Make sure that kind of stuff.
I've had an adjuster very recently tell me that injuries that my client had were not caused by the accident because they were on one imaging source and they weren't on another imaging source. And the first place they went to, they got an x-ray done. And, x-rays don't show that much aside from bone issues, where an MRI is the more powerful imaging source. My client's injury showed up on the MRI, but it was 6 months later. And they're saying, well, it's obviously not caused by this accident because it's so far away from the accident date that it couldn't be the same, and it didn't show up on the first imaging. Well, when they said that, I pointed out the difference between an X-ray and MRI, and they changed their tone almost immediately. So I think sometimes adjusters make mistakes when looking at cases, and you really have to know your client's medical to differentiate it. And the other thing I'll say, you said getting your client a second MRI. Also important to look at the subjective complaints that your client had in the earlier treatment. Very important, because often it's much different after the accident. So you can actually highlight those things. Look here, they had no numbness and tingling going down to their fingers, and then after the accident, we think that there's a herniation, and look, now there's numbness and tingling, and really show a new injury, essentially.
Right. And then sometimes, too, yes, and sometimes those cases have to play out, too. You want to let that second accident play out. Your client could be done treating in 2 months. Then it's a very case should settle. Your client also could treat forever and go a long time, and you need to be able to prove that. And so there's a lot of issues coming and going, but bottom line, there's a lot of tricks that the adjusters can try to play on you. Let me say it this way. There's a lot of techniques that the adjusters can use to you. Sometimes they're tricks and sometimes they're legit. So you want to listen to that adjuster. You don't just say they're full of it. You want to listen. They may be pointing out good things to you that you need to reevaluate and talk to your client about. But you need to always filter everything and look at it, figure out if it's a trick or not, how to combat it, deal with it, and try to persuade the adjuster. And if you can't, file suit and litigate it. So, any other last departing thoughts, Stephen, on adjusters' tricks and how to combat them?
I think we covered most everything I had here today. Thank you for having me on here today.
Thanks for coming and thanks for talking to us. Everybody, this has been Lawyer to be Lawyer. If you have any other questions about dealing with adjusters, Stephen, if a lawyer, I know you always answer questions for free for people. Where can they get a hold of you?
You can give me a call at 314-222-0066, or you can email me, very responsive to email, at Stephen, Stephen, at GerringLaw.com. That's GerringLaw.com.
Great. Thanks, Stephen, so much for all the prep work you did for this and all your insights, because I know your techniques have had a lot of good effect for your clients. Thanks for working so hard for your clients.
You're welcome. Thanks for having me.
All right. Take care.